Good morning, Your Honors. The matter before the court this morning is a case entitled Miriam Lowell and Seth Healy v. Department for Children and Families et al. Case number 23 AP 323. Representing the appellants, Miriam Lowell and Seth Healy, is attorney David Schlansky. Representing the appellees, Department for Children and Families et al. Is attorney David Groff.
Thank you very much, and good morning, counsel. We'll hear from counsel for the appellant first. Of course, please introduce yourself, identify your clients, and then proceed.
Good morning, Your Honor. My name is David Schlansky. I represent Lowell and Healy. Thank you for your time today. I'm going to speak for a few minutes, and then I'm happy to answer any questions. I'm going to reserve some of my time for rebuttal. In this case, we're not speculating about what might happen anymore in a proceeding. This proceeding has happened. And what's been represented to the court about the proceeding in yesterday's filing is inaccurate. That letter suggests that at that proceeding, there was a clear allegation of what the accused was accused of. Ms. Lowell actually went to a proceeding where she was told, here are some papers, figure out what it is that you might be accused of and rebut it. So we had a free range discussion that touched on many matters, not just any type of risk of harm for physical injury, but also risk of harm for neglect, actual neglect, all of which have abstruse definitions within the department's policies, which purport
Mr.
to have
Swinsky,
force of law.
on the information that was submitted yesterday,
Yep.
that she was not substantiated.
Yes, sir. In an improper process where it was a toss-up. She had to guess as to what she was accused of. There was no accuser. There were papers that she was told to figure out what the papers might be saying and how she can defend herself. And that toss-up was a 50-50 because in each case, there was nobody there to clarify what was even alleged to be accused. This was an inquisitorial process that frankly resembled something from another judicial system.
But then she prevails.
It does not moot her claim.
Well, whether that moots her claim or not moots her claim, doesn't it affect her argument regarding the ability to have a fair hearing?
No.
It does
No, it
not?
doesn't. No, if she had gone into a casino and played at a roulette wheel, she and Healy would have probably, one ended up on black and one ended up on red. This process did not resemble anything remotely approximate to what is the idea of being accused of something that's going to affect a liberty interest.
What is the relief that you'd be looking for here, Mr. Schlansky?
Well, first off, Healy is before your honors today, but what she is looking for is a determination that she has been subjected to an improper process. And that itself is a harm in and of itself that's cognizable in these United States. At this point, yes, it's true she prevailed, but the manner in which she prevailed, having to guess and having to fight her way through a bunch of fog, is not itself a fair process at all. And Healy
Mr.
was harmed by
Schlansky,
this.
Mr.
Yes.
Schlansky, you seem to be is the chief still with us, Emily?
Yeah.
Okay.
I'm sorry, the video cut out for a second.
Good. Mr. Schlansky, you seem to be arguing in your response to Mr. Groff's memo. He doesn't talk about Mr. Healy, but you do in your response, and Ms. Lowell. You seem to be arguing damages here. The only issue on appeal is whether the court erred by finding that this process met due process requirements. And so how does the damage that either of them might suffer, whether it's monetary or otherwise, how is that on appeal here?
Well, so there were at least two elements of what was sought in the trial court. One of them was an injunction to prevent this from happening and to provide a proper process, and the other was mandamus. This court's case law makes clear that mandamus is not mooted in retrospect. There can be.
But you're asking I'm just going to follow up on your thing, Justice Carroll. Go ahead. You're gonna ask probably the same question I am, but go ahead.
Well, how does mooting out a process, or how does calling a process violate a violation of due process affect your client at this point? What is her interest right now, other than potential damages for the process she went through?
Her
What is her
interest
interest?
Her interest is
Particular to her, I'm sorry,
well,
particular to her.
she and her child, who is one child that's in her custody at this point, have an interest in not having to worry about associating with Healy. She also has the risk of having this recur. If it were to recur, she would be, I mean, one doesn't have to speculate that being separated from her child caused great harm to her.
I'm sorry to interrupt you, but what did you say associated with Healy? I didn't quite catch that.
Yes, sir.
How did you phrase that?
What the state doesn't say is that this improper free-ranging process, which includes extra record, ex parte review, all sorts of things that are incommensurable with a liberty interest and with the state's law for due process, or federal law for due process. The state doesn't volunteer it, but that was determined adversely to Healy. This is consequential to a family. It's
So what
consequential to
liberty
recurrence.
interests are you referring to, Mr. Slansky? Because this is not a criminal proceeding. So
Well,
what is
it's
your
not a
liberty
criminal
interest?
well, under the state case law, she was bounced from it. She was terminated from a job because of the published statement by the worker that she had been substantiated for child abuse.
And doesn't that go back to Justice Carroll's inquiry as to, are you requesting monetary damages?
My client may amend in this court. My client has actually dismissed without prejudice in federal court pending the outcome of this determination. But I think the case law is clear that as regards mandamus, a matter that is wrongfully brought is not mooted by the determination favorable to the person who was subjected to that wrongful process. And that's a problem in and of itself. And let me give an example. If somebody were charged with a crime and were give an example, say tried with quotes around tried by a traffic magistrate, and the crime was a felony. If the magistrate dismissed the charges or had a trial and said, you're free to go, it doesn't undo the process harm. It doesn't undo the case for mandamus.
Mr. Schlansky, you said that your client was fired. I didn't think she was fired from her job.
She was fired from a job several years ago when the employer found out that she had been substantiated for child abuse. She's subsequently become reemployed. But so this is an interesting point I want to clarify. The employer, it's unclear whether the employer actually checked the registry, because Ms. Lowell was, to our awareness, not on the registry at that time. But the employer found out that the caseworker had said that she had been substantiated for child abuse. That caused her to be terminated immediately.
And then she was rehired by that.
She found another job that did a de novo check of the registry without Ms. Lowell volunteering.
And I have one more question for you while I have you. What is Mr. Healy's status right now? He was substantiated, but did he go through the initial review yet?
Yeah, same day, different proceeding.
Okay.
And I
what
would
was
say
the
that
result of that?
well, I would say same facts, different outcome. They're slightly different presentation, but that's part of the mercurial aspect of this whole thing.
Okay, so where is that? That's not part of. Go ahead. We're going to ask the same thing.
We didn't bring the motion.
I want
This
to know
all
what
happened
happened to
recently.
Mr. Healy. He was substantiated. We have a process of the review hearing, and then you can appeal that. Where is he in that process?
Well, so he has not had an opportunity to confront any accusation. He went through the review hearing.
Yeah.
It's not called a hearing, it's a review.
Okay.
He was substantiated. He is now listed, so he has suffered that harm.
Has he
And
appealed then?
It's still in the period, but he's certainly going to.
Okay,
And-
so that's just what I don't understand, Mr. Schlansky. Is that seems like there was an agreement in place that whole process was going to be on hold pending a decision from this court on your appeal. And then in the interim, it seems like there was an agreement between you and DCF to go forward with the administrative substantiation review, which Ms. Lowell prevailed on, and you're saying that Mr. Howell did not prevail on, but now he has a right to appeal that to the board. I mean, so has he not
No,
exhausted his administrative remedies yet?
no, this is the whole idea of a liberty interest. One has a pre-deprivation due process compliant proceeding. That has never happened for Healy. Healy is being given a post-deprivation proceeding. And the agreement, we thought we had an agreement too, but the department said that it's going to unilaterally substantiate these people if we don't show up to these coercive proceedings. We did not want to go to this proceeding, but we had to, at risk of
That's
default.
how the Sylvianic case plays into this.
Sorry, the Sylvianic case,
Yes.
Your Honor?
Yeah.
Well, Sylvianic, this is a great question, and it's at the state's brief. To boil it down very clearly, it's at the state's brief at page 11. Sylvianic, according to the state, and this is its brief, in the middle of page 11, if I said 7, I apologize. Sylvianic concluded that a, quote, higher standard at the investigatory state, close quote, was not necessary, quote, because of the availability of the Human Services Board hearing at any time after inclusion in the registry. This is exactly reversing the order of operations. One gets a pre-deprivation due process compliant proceeding if one is accused of something that is a liberty interest impinging accusation. So Sylvianic is saying, it's talking about what process are you due in this novel conception 30 years ago of something that's purely at the investigatory stage. But now it's been supplanted by, this is a clear requirement that before a liberty interest is taken away, such as a job, you have a pre-deprivation due process compliant proceeding. So Sylvianic is an apple when we're talking about oranges here. It's talking about investigatory process within the agency as opposed to pre-deprivation determination compliant with due process. I'd like to reserve my time, but I don't want to refuse any questions.
I have one more question, Mr. Schlansky. Justice Cohen talked about exhausting administrative remedies. So Mr. Healy now has had his review hearing. You said he intends to appeal that to the board. Why should we not wait until that happens
100%.
before deciding that he was deprived of due process?
This is exactly.
Let me
I'm
finish,
sorry.
please.
Yes, sir. Sorry.
Wouldn't we want to wait until that process is finished to make the determination as to whether he had due process?
I apologize for speaking over Your Honor. This is exactly the separation of powers issue. This is internalizing an adjudicative process impinging on a liberty interest into an administrative process. This is not an administrative remedy. This is an adjudicative process that's proper for a judicial body. And the proof of that is this is a fundamental due process stigma that applies for somebody's lifetime. It's highly akin. It's not just rhetoric to say it's highly akin to a criminal matter, because this court's own authority says that this is a liberty interest. We don't need to speculate about whether Ms. Lowell is going to be bounced from her job. She was bounced from her job. We don't need to speculate about whether this process has all these free-ranging inquisitorial processes where somebody says, there's nobody here to tell you what the accusation is. I interpret this a lot of different ways. Defend yourself. It's incumbent, the spotlight is on the defender to explain what she might be accused of doing and how she didn't do it.
Mr. Schlansky, am I incorrect by saying that there was not an informal agreement to hold off on any administrative review pending this court's decision on your appeal from the civil division?
You're right. There was an agreement, and the state went ahead and said that it is mandating that we proceed in this way. It was coercive, Your Honor.
I'll.
You have 1 minute left, counsel.
I'm going to reserve it if I may. Thank you.
All right. Thank you very much. We'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. This is David Groff for the department. There can be no doubt that Vermont has a compelling interest in protecting children from abuse and neglect. The registry, the Child Abuse Registry, is one important means for Vermont to implement that important interest. In light of the importance of that interest, the due process protections that are provided pre-deprivation to those accused of abuse more than meet the constitutional standard. And the court mentioned the Sullivanic case. That case decided 30 years ago that the procedures in place at that time met the due process standard. Merely having a standard that approximated or that was the equivalent of a preponderance of the evidence standard, and having a post-deprivation review at the Human Service Board, this court held 30 years ago, met the due process standard. Since that time,
Mr. Groff, so the 2007, maybe this is what you're just going to say. I don't mean to cut you off on it, but the 2007 amendments, do you agree that they create additional due process protections for an individual?
absolutely, absolutely. They create an entire new layer of pre-deprivation protections that didn't exist at the time that Sullivanic was decided. So those protections include informing the substantiated person, informing them about the registry, informing them of their review rights, giving them this review to an impartial administrator, giving them the evidence the state has relied on, allowing them to come and tell their side of the story, allowing them to present evidence. None of that existed at the time of Sullivanic. It's now all provided pre-deprivation. The only thing that's not allowed is cross-examination and calling witnesses. I mean,
not at that level, but they were at the level of the board. You are entitled to call witnesses and cross-examine witnesses, correct?
Absolutely.
So can you just explain to me how we got here with what was filed this week? Because again, I think this was all on the assumption that the administrative review process had been stayed pending a determination of the appellant's appeal.
Oh, right. With all due respect to my co-counsel, there was never such an agreement. There was an agreement when this case was filed in federal court to stay the administrative procedure pending the resolution of the initial determination by the federal court of whether they were going to impose different standards. Once that was decided, the state intended to go ahead with the administrative process. In fact, the state on multiple occasions has opposed motions to stay the administrative proceeding filed by these plaintiffs. Now, it so happens that the review didn't take place for a long time. One, because first it was stayed by the federal case, then COVID happened. There were no reviews happening in person. They were only being held remotely. These plaintiffs would not agree to appear remotely. After that, there were frequent requests for continuances by the plaintiffs. Eventually, Mr. Counsel is correct that the state said, we're going to hold this hearing. If you don't appear, then we're going to hold it anyway. And so they finally agreed to appear at the hearing. And lo and behold, one of them prevailed entirely. The other prevailed in part. So, which just goes to show, Your Honors, that this process, doesn't describe a denial of due process. This is due process. There's a process here to be utilized by those accused of abuse. It's an extensive pre-deprivation review process.
Mr. Groff, I'm sorry, what do you mean that one of them prevailed in part?
Sure. So let me clarify. At the administrative review level, the review that was held on the 4th of this month, I think, or maybe the 5th, don't hold me to that. All of the substantiations against Ms. Lowell were overturned. Mr. Healy was facing substantiations for the same essentially set of charges that Ms. Lowell was, which was risk of abuse related to the children and drug use, what have you. He also was facing a substantiation for physical abuse of one of the children for a particular incident. The substantiations on the risk of abuse for him were overturned. The substantiation for the physical abuse was upheld.
Oh, and let me just follow that up with, what's your position? You didn't mention him in your motion that you filed. What's your position about where we should go, given the status of what you just described?
So I think the reason we didn't include him in our motion is because the one claim remains, and because he has remaining remedies, it's not moot. I would agree with Your Honor that he should exhaust those remedies. I mean, the legislature has created a path for these claims to proceed on. There's the pre-deprivation due process, there's the post-deprivation full hearing at the Human Service Board, and then there's an appeal to this court. That's the way these cases should have proceeded. The plaintiffs chose instead to file a separate action in Superior Court, which essentially was a collateral attack on the established administrative and judicial procedure. Now, interestingly, the plaintiffs raised Axon to say that the court had an obligation to determine the constitutionality of these procedures, but it seems to me to be a very curious objection, because the Superior Court did determine the constitutionality of these proceedings and found that they met the constitutional minimum. I also want to clarify, the question arose, what type of liberty interest was at stake here? In their briefing, not today, but in their briefing, the plaintiffs seem to allege that they have a constitutional interest in family integrity, and they make some allegations about the children being removed. But as a matter of law, being substantiated and put on the child abuse registry has no impact on custody determinations. As Your Honors are well aware, custody determinations, when the state is involved, go through the CHINS or the TPR process. Also, of course, private parties can dispute custody and divorce type proceedings, which is what happened here, as alleged in the complaint, if you read it thoroughly. But being put on the registry has no impact on someone's ability to live with their children. In fact, again, in Sullivanic 30 years ago, this court held that the legislative goals, functions, and procedures in these two proceedings are completely different. And this court has repeatedly held that a finding of substantiation in the context of the abuse registry is not determinative of a CHINS proceeding, for example. So the only potential consequence is employment related. Now, counsel today has made representations about his client being fired. Those allegations aren't in the complaint, and frankly are not true. Ms. Lowell was never on the registry. I believe the truth is that Ms. Lowell herself told her prior employer that she had been substantiated, and that's what resulted in her being terminated. That's not in the record, but the state never told her. She was never on the registry, and now never will be. Now, so the claim is moot. It's clearly not capable of repetition yet evading review. So her claim should be dismissed. Mr. Healy has no liberty interest at stake here. He doesn't work in the field of childcare.
Okay, so is there a potential taint to Mr. Howell by being substantiated in any way that would affect him?
So at least on the federal level, the courts have found that the type of interest at issue there, which is essentially defamation, a defamatory, an interest in your reputation, while an appropriate subject of tort law, is not of constitutional significance. So that's what the Second Circuit held in Valmont versus Bain, and what the Seventh Circuit held in Dep't. It's only where where being on the registry kind of as a matter of law would preclude you from pursuing employment that the federal courts have found that there's a liberty interest. And we think the same should apply here, especially given the importance of the state's interest in essentially making sure that known child abusers aren't in jobs where they have custody of children. I mean, that's an important interest.
But Mr. Groff, what if I can see if Mr. Healy was substantiated through this entire appeal process, doesn't he have an interest? I mean, he doesn't have to be a teacher or work in a daycare. He could be a custodian in an elementary school. I'm sure they ask for permission to look at the registry on anybody who's around children, really. I just have a hard time trying to figure out why he doesn't have an interest in being a substantiated child abuser.
So I don't believe he's alleged that he's intending to solicit employment in any type of setting where children are. I'm not sure. Unfortunately, I don't have the statutory language in front of me or memorized, so I'm not sure it would reach custodians. I mean, Your Honor raises a valid point. But he's never alleged that he's pursuing such employment. And ultimately, he has procedural protections in place anyway, pre-deprivation, post-deprivation, full hearing at the Human Service Board, and appeal to this court. So even if he has a liberty interest, adequate process is being provided to him through, we just look at the classic test under Matthews versus Eldridge, and we compare the plaintiff's interest with the state's interest and then decide whether additional proceedings are necessary or whether they, any added burden would outweigh the benefits. And I think clearly here we have what is pretty extensive pre-deprivation process, only lacking cross-examination, essentially. We have a full post-deprivation hearing at the Human Service Board and an appeal to this court. And respectfully, we believe that's more than adequate due process. And we ask that the decision below be affirmed. So unless there's any other questions, Your Honors.
All right. Okay, thank you very much. How much time does the appellant have, please?
Appellant has 54 seconds remaining.
Counsel?
Okay, the only things that I would say is that certainly there's a liberty interest in favor of Healy. He's foreclosed from seeking employment in various places where he'd be embarrassed and humiliated to try to seek it. But he certainly would like to be a custodian. He'd like to volunteer for Children's Little League, things like that. Those things are foreclosed at this time. Case law is clear that that's a liberty interest. But the idea that the only thing that's lacking about this proceeding was cross-examination is not accurate. Unfortunately, I attended it, and what was lacking was even a clear accusation of what was being alleged, let alone anybody to testify. Effectively, my client was left to face a process where she had to explain how any possible inference from these papers was untrue. This is a definition of a free-range inquisitorial process, and that doesn't comport with state law, and it certainly doesn't comport with federal law, and it is susceptible to a direct attack on grounds of constitutionality.
All right. Your time has expired. Thank you very much. Thank you both. Please call a conclusion of the hearing.